Hello, everyone, and thank you for joining us at the Legal HR Summit. The Legal HR Summit is a two-day online event hosted by Jus Laboris, the largest employment law alliance in the world. This session is the last session of the Americas block. I am now turning over to Tiffany Downs to begin the session. Go ahead, Tiffany, you can start.
Thank you, Annie. Welcome, everyone. Thanks for joining us today. As the world of privacy is getting more interesting, as I'm going to give a little background about, we're going to talk about the Privacy Shield and the impact of the invalidation of that by the Court of Justice of the EU. But first, I'd like to introduce my panel. I have first Sylvia Araujo, who is with Verano, member of Jus Laboris in Brazil. And then I also have Patrick Burgo, who is the General Counsel of General Counsel of Hayes PLC, a worldwide recruiting firm, and his jurisdiction is EMA and the Latin America. So today we're going to talk about what the Schrems ruling was, the impact of that, and then Patrick will give us a little insight on what companies are doing after Schrems, how to manage the privacy requirements. And then Sylvia will give us, Brazil, I guess, was feeling left out, and so that they've now decided to introduce their privacy regulation, which I believe went into effect in September. So Sylvia is going to give us the high-level overview of that law, and we have the questions open, so at any point during the conversation you would like to ask questions, please do that. And we're going to start with a poll. Annie, would you please launch the first poll? So we want to find out, prior to the Schrems decision, what mechanisms did you or your company use to transfer HR data across the Atlantic or across different countries? Vote and let us know, and we'll use that to guide our discussion today. Annie, would you please turn to the first slide? Thank you. So here I wanted to give a little background about GDPR. If you have a multinational company or you are transferring data to maybe some of your service providers or using the cloud, you potentially are transferring personal data across borders. And depending on what country you're in, you have to take into consideration whether the country you're transferring the information to has adequate protections to the data subjects. The European Union, after Edward Snowden filed a complaint about the US access to personal data, there's been a lot of discussion about the EU and the US and the protections that the US laws provide. So there were, as part of GDPR, most of the European countries have been determined to be adequate, and so they can freely share information. The US, because of concerns about the access of NSA and FBI and CIA being able to access some data, it was adopted, the Privacy Shield was adopted that has certain protections in place to protect the information. In July of this year, the European Court of Justice invalidated the Privacy Shield and determined that it was invalid, but it did thankfully recognize that companies could still use standard contractual clauses to transfer data across borders. But the way the opinion is written, you can't just say, okay, we have a standard contractual clause. You have to do more. You have to do an analysis of whether the paper is fine, but you also have to determine whether protections are in place as applied. So you may have the standard contractual clause, but is the other vendor following the clauses? And then from a practicality or based on application, is it actually protecting the data? So it requires a deeper analysis into looking at whether the data is actually being protected. And so some of those things look at whether looking at the contractual clauses, is it applicable? whether the data is secure, whether you have to implement supplemental measures, such as additional provisions. Typically, the standard contractual clauses cannot be modified. But here, what the court seems to be suggesting is that you have to have additional protections in place, such as additional contractual protections. And there is a German data protection authority, the Baden-Württemberg Data Protection Authority, that proposed some additional contractual clauses that could be added. And so that could be an avenue for which additional protection could be provided. And also you have to prove that you as the data importer or the processor did some due diligence in looking at whether the data is accurately protected. So that's where we are now. So the privacy shield is out, and then companies are kind of left wondering what they can do to comply with the GDPR and adequately protect the data. Let's look at the results of the poll, Annie, to determine. All right, so the poll says most of the people use binding corporate rules. So the GDPR says that you don't have to have anything in place if there's an adequate determination if you're transferring data between two countries and it's determined to be adequate protection. The second way to do it is looking at whether there are safeguards, and that's where the standard contractual clauses come in, or the binding corporate rules, or if need be, Article 49 derogations in the GDPR, which typically can be consent or some kind of contractual provision. Binding corporate rules are kind of used to be the gold standard of transferring data, although it is not a quick process to get in place. So it's interesting that for a quick fix after the invalidation of the privacy shield, it's probably not a quick fix, but that is interesting that people are relying on that, which I think is good. Although the Shreem's court somewhat questioned the validity of the binding corporate rules without really making any determination. The court just said you need to go back and look at all of the measures that you're using to transfer data, including binding corporate rules. So the binding corporate rules in and of itself may not be sufficient. You may have to include some additional protections or provisions to make sure that the data is protected. Okay, with that, so Patrick is later gonna talk to us about what it is in application, but for now I'm gonna turn it over to Sylvie, who's gonna give us some background on the Brazilian privacy law. Sophie, take it over. I'm sorry, Sylvia.
Yes, thank you, Tiffany. And thank you for the invitation, and thanks for Use Laboris for planning everything, and Patrick for joining us. So, well, in terms of Brazil, we finally have the first specific legislation on data protection. Our law was, the LGPD was signed into law on August 2018, but it only came into force on last September 2020. And the administrative sanctions and fines are postponed to August 2021. So companies in Brazil are still reviewing their internal policies and documents and protocols to adapt them to be in compliance with the new law. And the LGPD repeats or replicates some key points of the GDPR. And like the GDPR, it is not a labor law, but of course it has several implications in employment relationship. Companies process and collect employees' data and candidates' data all the time, including names and address and ID and salary and everything. And for some companies, some businesses, it's critical to transfer this data internationally for like outsourcing employees payroll or benefits to a provider in another country, or sharing employees list and information with headquarters, HR in another country, or even when you are monitoring emails, the employees' corporate emails from an IT department based outside of Brazil. And so the LGPD in Brazil authorizes the international transfer of data, but only in specific cases, like very similar to the GDPR. And although the Schrems decision is made in connection with Europe and the USA transfers, it affects the transfer to any non-adequate country, that is the case of Brazil. And we have, for example, in Brazil, the LGPD authorizes international transfer for countries that have a level of data protection considered appropriate by the competent data protection authority. But Brazil does not have a data protection authority operating now. The LGPD created the data protection authority, and there was, after that, a decree by our president providing the structure of the authority, and 5 names of directors have already been discussed and approved by our Congress for this authority, but this is not operating yet. We expect to have it in a couple of months. But at this moment, it's very unclear in Brazil how the Data Protection Authority will address this matter of which countries can be or not be considered as having an appropriate level of data protection. And talking about the standard clauses, this is also a mechanism for international transfer. And similarly to GDPR, the LGPD provides that the definition of those standard clauses must be, the content of those standard clauses will be defined by the Data Protection Authority. So at this moment, as we have options for international transfer, that depends a lot on how the Data Protection Authority future decisions and guidances. At present, the legal basis that makes more sense to be used by companies to international transfer of employees' data seems to be intercompanies agreements and the specific contract clauses with third parties like payrolls and the benefits providers, establishing the responsibilities to be in compliance with our LGPD. And those clauses normally now, they are based on the content of the standard contractual clause approved by the European Commission, because as expecting that our Data Protection Authority in the future, when it is really operating, will approve a similar clause to that. So this is how we are dealing with that in these terms. And the main impact of the Schrems decision seems to be that how those clauses are being implemented, as Tiffany was saying. The decision made it clear that the standard contractual clauses are not absolute and they can be not sufficient to be in compliance with the laws, and the same for Brazil, especially when you are transferring the data to a country that have laws or practices that make effectiveness of such clauses unfeasible. So companies will have to be concerned on how the recipient of these data will actually process and this data, and not only to have the appropriate language or appropriate clause in a context. So such companies or some companies tend to use the employee's consent, the legal basis of employee's consent, which is possible as per our LGPD. This is a lawful basis provided by our law. But the law says that it must be a freely given consent and an unambiguous consent given by the data subject. And when we are talking about employment relationship, this topic always open a discussion. We have the concern that normally it's presumed that the employee is not really free to give or to refuse to give any consent to an employee due to the imbalance between the employee and the employer. So in addition to that, the data subject can revoke, as per the law, the LGPD can revoke the content at any time. It may be critical for some companies that need to process this data internationally. So the content is not our first option for legal basis to allow international transfer of the data. Although even when we are working with intercompany agreements or specific clauses with third parties for international transfer, the employer has the obligation to inform the employee the details of this international transfer for transparency. That is one of the principles of the LGPD. So it's by employment contracts or by employees' notes or policy, companies in Brazil are being prepared to inform the employee which data will be transferred, what is the purpose of this transfer, and to where it will be transferred. All those details must be informed to the employee as part of obligations by the LGPD. And so the concern in Brazil is the LGPD provides that any data subject that have any suffered any damage, material or non-material damage, can sue the company that is, or the individual that is responsible for that damage. So we are concerned on not only about the fines that the data protection authority can impose against companies in violation of the LGPD, but also on labor claims or investigations by labor authorities about the non-compliance of this LGPD. Because when we are talking about international transfer, if someone decides to sue a company, of course, in a labor court, we do not expect that a judge will call the company that is the recipient of the data to prove anything. It will be a matter of the company in Brazil to prove how it was transferred, what was the documents, and what was the enforcement mechanism to that transfer. So the employer is the one directly responsible for any damage to the employee. So in the end, the scenario that we have now in Brazil is that's not only a matter of having the appropriate documentation, but also to guarantee enforcement of our law of LGPD when implementing the transfer. It's not an easy task. We expect to have a lot of questions about that, and it's a multidisciplinary task. In fact, it involves the HR, legal, but also IT solutions, to make the enforcement of these mechanisms. And this is how we are in Brazil now. We expect to have a data protection in a couple of months. Companies are using this period now until we have finally the fines to be applicable after as of next year, to adapt and to review their protocols to be prepared for the LGPD that is already in force. But we still have some unclear aspects to be defined. And showing this DPO's point in the slide, DPO is one of the similarities between GDPR and LGPD also, although there are some difference between them. Both the laws provide the need of a DPO. In Brazil, the LGPD provides that the controller must appoint a person that will be the one responsible for the communication channel between the data subject and the controller of the data and the supervisory authority and the government, and it's also responsible to put in place the instructions by the controller. So this is also a concept brought by our new law. So this is where we are now. And I think that I'm curious now to know from Patrick how the companies are dealing with such a lot of news about data protection in Brazil and the other countries.
I think you're on mute, Tiffany.
Sorry. What is the, are companies going to be able to comply with the LGBT and GDPR at the same time, or are there conflicts between the two laws that are going to make it difficult?
Is that question for me, Tiffany, or for
No,
Sylvia?
for Sylvia.
Well, you know, some multinational companies in Brazil were already prepared for LGPD because of the GDPR. You know, the LGPD is very heavily influenced by the GDPR. So there are a lot of similarities that helps companies that are, you know, that are in Brazil but had headquarters in European countries that are already prepared for that. So it's not so difficult to put everything in place. But of course, there are companies that were not submitted to the GDPR and have not any headquarters there, or is not a multinational company. So they are, you know, more concerned about how to implement the LGPD rules.
So they're starting from scratch, yeah.
Yes, starting from scratch, exactly.
Okay, I think we have, before we start with Patrick, we have another poll. Annie, would you put up the second poll, please? And this one is just asking about, after the decision, have you or has your company made any changes to how you're going to transfer data across borders? So that's the question, using standard contractual clauses, binding corporate rules, or you don't have a plan yet and it's to be determined. So we'll leave that and I will turn it over to Patrick. Annie, you can advance the next slide, please.
So let me see if I can persuade you as to how you should be answering that question. As Tiffany said, I'm General Counsel for EMEA and Latin America at Hays, which is a global specialist recruitment company. And I deal with 19 jurisdictions, most of which are in the European Union. I'm an English qualified lawyer, which is why I sound the way I do, but I'm actually based in France. So I led the Hays GDPR project to prepare Hays for GDPR in 2018. And this involved a huge data mapping exercise on the basis of which, in conjunction with our external legal advisors, we designed a set of compliant policies and documents for that. And I've been working with Sylvia's law firm, Fairytale, in Brazil on the implementation of a compliance process for LGPD. So like many service companies, Hays does not deal in tangible products. Its value is in its data, much of which is personal data, both in relation to candidates for recruitment, because we're a recruitment company, but also Hays staff. And we have about 11,000 employees globally, with a presence in 34 countries. And we encourage staff to be internationally mobile, which necessarily means international transfers of personal data of Hays staff. Again, like many global companies, Hays has its core activities carried out in offices around the world, but also a number of ancillary activities, both internal and targeted at clients. We have a number of shared service centers around the world, the largest being in Gurgaon in India, which support the global businesses and carry out some of the data processing activities, as well as supporting the Hays IT infrastructure. And we also have a proprietary software solution which allows Hays or its clients to manage personal data of internal and external staff. This is or was based in the USA, with the data originally being hosted on servers in the USA. All of these structures were reviewed for compliance with GDPR ahead of GDPR coming into force. Now, as we've heard, some countries have a European Commission adequacy finding in their favour. So this is where the European Commission considers that local laws and enforcement mechanisms in those jurisdictions provide adequate protection for the personal data of EU citizens. And let's not forget, we are talking about the data of EU citizens, or EU, yeah. This includes Argentina, Canada, Uruguay, Japan, and a number of other sort of so-called whitelist countries. It doesn't include India, which I mentioned earlier, and it doesn't include the USA. Hence the establishment of the Privacy Shield. And as the Privacy Shield has been invalidated, like Safe Harbor before it, this leaves multinational businesses having to find another way to legitimize their transfers of personal data of EU residents outside the European Economic Area. So how would we define a restricted transfer, i.e. a transfer to which GDPR would apply? So basically, you're making a transfer if GDPR applies to your processing of the personal data that you are transferring. You're sending the personal data or making it accessible to a receiver to which the GDPR does not apply, i.e. it's outside the EEA, and the receiver is a separate organization or individual. Critically, this includes a separate entity, even if it's within the same group of companies. So, for example, you could have a French, Spanish, and UK company, or the French, Spanish, and UK subsidiaries of a US parent using a centralized human resources service in the USA provided by the parent company. The European companies pass information about their employees to the parent company in connection with the HR service. And that's referred to as a restricted transfer under GDPR. So how can we legitimize that? Well, there are basically three options, as you can see on the slide. So standard contractual clauses, which we've already mentioned, binding corporate rules, and the Article 49 derogations under GDPR. Let's just take those in reverse order. So Article 49 derogations may apply where there's no adequacy finding in relation to a particular jurisdiction, and there are no appropriate safeguards in place, such as standard contractual clauses or binding corporate rules. So that could be that the data subject has explicitly consented to the proposed transfer, or that the transfer is necessary for the performance of a contract between the data subject and the data controller, or that the transfer is necessary for the conclusion or the performance of a contract that's in the interests of the data subject. Then we have binding corporate rules, which were created under the previous EU data protection law, actually, so 1995, and they were designed to allow multinational companies to transfer data outside the European Economic Area. They remain valid under GDPR. They require a company to choose a lead data protection authority, usually the authority where a business is registered or has its largest operations, and to agree a set of rules regarding the safeguarding of personal data within the group. The lead authority then seeks to ratify those arrangements by consulting other relevant EU data protection authorities and seeking their approval. Once approved, they provide a long-term solution to those transfers. However, crucially, they're only valid for intra-group transfers, and processing and obtaining binding corporate rules is a really lengthy process. We're talking for a straightforward one, maybe 12 months. For some of the more complex matters, you could easily spend 2 years or more trying to negotiate and agree them, especially for a large multinational. Consequently, the more popular approach is standard contractual clauses. So these were drafted by the European Commission and appended again to the old law, so pre-GDPR. They were revised subsequently, but still prior to GDPR, and they have not yet been revised post-GDPR. So within those clauses, there are some conflicts with GDPR, and also some conflicts with, as Tiffany mentioned, which have been raised in the Schrems decision. So those clauses, they're standardized contractual clauses. They can be used within agreements, or they can be used as standalone agreements to ensure, again, that personal data that leaves the EEA will be transferred in compliance with EU data protection laws and meet the requirements of GDPR. There are two basic versions. There's controller-controller clauses, and there are controller-processor clauses. And the rule is that if they're signed in unamended form, they're considered by the European Union to provide appropriate safeguards. Now, obviously, they're not just pieces of paper, which again is something that Tiffany and both Sylvia hinted at, that you do actually have to comply with them. And I think that there is something of a ticking time bomb with many businesses being quite happy that they've signed model clauses, they've papered what they do. But if you dig a little deeper or scratch the surface, you will find actually that they're not doing anything like what they have contractually committed to be doing. So what was the Hays? This doesn't apply to my company. Obviously, we have done exactly what we said we'd do. So what was the Hays approach? Well, we basically prepared a monster agreement to include the 200 or so Hays entities around the globe, with each entity, to the extent that it has a particular role, such as controller or joint controller or processor, committing to abide by the relevant contractual commitments made in the event of any data processing or data transfer activity. So the agreement therefore incorporates all sets of standard contractual clauses across the entire business. I should point out at this juncture that we did not at any point seek to rely on the privacy shield. So before we look at next steps, do we have the response to the poll? Okay, well, that's clear, isn't it? So no standard contractual clause. Okay, no. Well, hopefully I'll be successful in persuading you that standard contractual clauses is the way to go. So what should you do now, assuming you were hitherto relying on the privacy shield? Well, first of all, as just to point out, this will apply to all personal data, not just employee personal data. I appreciate that we are talking at an employment lawyers conference, but nevertheless, all personal data is relevant in these arrangements. So first bit of advice is, of course, identify all transfers that are based on the privacy shield. Secondly, continue to comply with the privacy shield for the duration of your certification. And then thirdly, convert to standard contractual clauses. So this is in practice a fairly straightforward process, and it has the merit of being within your control, i.e. if you use the clauses unamended, then once they're signed, you're done, at least in terms of papering what you do. Obviously, you do have to be in a position to have the infrastructure that allows you to comply with what you've contractually committed to doing. Bear in mind, of course, that if you have multiple client and supplier contracts that involve processing and transfers of personal data, then you'll need to undergo a similar process. So the internal HR data piece may actually be the easy bit. You may have a whole lot more to do behind that, and certainly that was the case with my company. Fourthly, you need to revise your data processing notices on your privacy or your privacy policies to reflect the new data transfer mechanism. This is critical, and failure to do this, or indeed failure to establish a legitimate basis for transfers of personal data outside the EEA, may lead to hefty fines. And then lastly, you need to consider the impact of Brexit if you have businesses in the UK. So until 11 p.m. on the 31st of December of this year, the UK is treated as being within the EU. Afterwards, as mentioned earlier by Tiffany, the UK may find itself in the same position as the USA after Schrems 2, and for similar reasons. So to the extent that your data is hosted in or transferred to the UK, even the SCCs may not save you. Ireland is becoming a very popular place right now for data. So I'll hand you back to Tiffany.
Yes. So I think part of the Schrems decision was really saying, like, you can't just sign a paper and think you're done, and it's requiring companies to do more. And so part of that doing more would be looking at when you're setting up a vendor, asking questions about have they ever had a government, because remember the Snowden, this all stemmed from Snowden, who basically outed the US government about the government asking for access to data for private companies. And so part of, if you're setting up a vendor or a service provider, you want to ask questions about, do you receive requests from the government for your data, to identify what the potential risk is. And so part of that due diligence could be in your procurement department and asking about, you know, what kind of data are you holding? Have you gotten government requests? And then part of those answers could be built into your contract with the company to make sure that you're providing protection for this that data, including telling the vendor that you want to know immediately if they get a government request for information, to allow you to respond. Have they ever responded? And so some of that background would be helpful to document as part of this risk assessment, to show if you're ever subject to any kind of audit or inquiry from a governmental regulator, to identify that you've looked at the potential risk. And we haven't talked about it as part of this session today, but I wanted to mention, if you haven't done a data protection impact assessment, that is a great thing to do, to identify, as Patrick mentioned, about where your data is flowing and to whom, and map it out, and then make sure that you have protections or mechanisms for all of that data if it's going to be transferred. And if you're ever subject to a governmental regulator inquiry, you can show that you really tried to think about all the different ways that your data could be shared, and that you have protections in place, encryption, restriction. So we call it kind of the defense mechanism, to show you really thought about it. And especially now, in light of this kind of land of unknown about, you know, what is permissible after Schrems 2, and the data protection European Data Protection Board met in July and started talking and thinking about, they're creating a task force to come up with some new standard contractual clauses, but it's no man's land right now. And so anything that you can do to document what you're doing and additional protections would be helpful. So not just relying on standard contractual clauses, but maybe trying to get consent of employees in certain circumstances. It couldn't be uniform consent, because the Schrems decision or some other decisions have talked about, you can't do it universally in an employment relationship, but you would need to consider the circumstances in obtaining that consent. So having kind of some safeguards in place, like option 1, 2, and 3, to justify your transfer of data would be a good idea. So revisiting kind of what you have in place, and then looking at what other mechanisms you potentially could put in place to give you protection. I think we've heard, or at least anecdotally, that the regulators may not be going after companies in light of this uncertainty right now, but that is not something to rely on for sure. Patrick, what about, do you, as far as your schemes, I know you talked about, did your company Hayes adopt like one universal policy that's basically applied in every country, or are there tweaks for each of those different countries?
The collective view, I guess, of the Hayes legal department was always that GDPR seemed to represent a high watermark globally for the protection of personal data. So our approach was actually to level up and to require businesses globally to work to that standard, at least to the extent reasonably practicable. and I guess subsequent developments in California and in Brazil would suggest that, at least from my perspective, it's not a flawed approach. In terms of regulating international data flows and data processing, we, as previously mentioned, we just prepared a giant DTA and DPA, which incorporates all EU model clauses and all Hays entities globally, and require businesses in countries with less protective data protection regimes to just work to those standards. I think that there is the odd tweak. Russia, for example, because they have a localization law, there are certain things that are specific to Russia. There are certain things that were specific to China also, and Singapore also, because of localization laws. But other than that, we pretty much managed to have a common approach, I would say, across all of our businesses.
Okay. And from a practical perspective, when you're entering into an agreement with another vendor, do you provide model clauses to them as to what has to be in the agreement, just from a practical perspective, to make sure everyone's kind of at the same level?
We try. It's an interesting one, because if we're within the EU, it is generally something that we're able to achieve, because especially now, a year or two down the line, even though the model clauses have been around since 1995, a year or two post GDPR, people are used to actually having to express an opinion on data protection issues, which they shied away from, I think, before. And I think that whilst we had a little bit of difficulty immediately post GDPR, I think there are a lot more model clause agreements around now, and there are only 3 separate sets, so people recognize them for what they are. And one of the interesting things I've seen more recently is that they often, you'll see in an agreement saying, we will comply with model clause set B. And they don't even bother to repeat all of the clauses anymore, or even append them to the contract, because there's that level of knowledge now. So it's become an easier ask.
Yeah. And Sylvia, do you have any other comments to add, or anything else to comment on?
Well, I think, we are in a moment that in Brazil, we still need something to be clear, but we are using a lot our experience with the GDPR that is in effect for a longer time, and using even the template or the models that the GDPR made available in this moment, that we still do not have data protection authority yet, or our legislation and guidance are not complete, are not full at that time. We are seeing that companies are really trying to be in full compliance with law, the LGPD, until next August, because this is when the fines by the supervisory authority will start to be imposed. And also, to try to be prepared as much as possible, because when we think that it can be not a very common in labor individual lawsuits, but it's a matter that interests a lot for labor authorities, public attorneys, and everything. So this is something that we would like, to avoid to have, and if we are in compliance with the LGPD.
So are companies using the GDPR templates and protocols until there's a data?
Well, yes, for SEC, while we do not have a template by our authority, and expecting that, as our law was very influenced by the GDPR, expecting that our authorities, when it is really operating, will approve similar clauses, at least similar. But of course, everything can change when the authority is operating,
Yes. All right, Patrick, do you have any parting comments?
I'm not looking forward to Brexit.
Yeah.
That's probably my parting comment, because I think we'll have a whole world of pain, especially as we're a UK-based company, even though we have much more business outside the UK. But there are still things filtered through the UK. So I think we've tried to be Brexit proof to the extent possible, but I think that it's difficult, and it will be difficult for many multinational companies that have used historically the UK as a gateway to Europe. I think those days are over. It's Ireland now.
Yes. Yes. All right. Well, I think that brings us, it doesn't look like we have any questions. So I think that brings us to the end of our presentation. I want to thank the panelists for their time today, and thank you for joining us, and stay tuned for coming developments. Thank you.
Thank you,
Thank you.
Tiffany. Thank you.
Thank you very much.
Thank you, Tiffany, Sylvia, and Patrick. We have now then reached the end of this session, which was also the last one of the Legal HR Summit. I would like to thank everyone for attending the summit, and thanks also to all of our panelists for their important insights. I hope you have found all the sessions useful. So thank you and goodbye.